Welcome to the Moran Center's virtual training on advising and advocating in family law. My name is Megan McClung, and I am the school-based civil legal clinic attorney. The Moran Center historically represents youth and young adults in criminal and educational proceedings, and started the clinic in April of 2018 in an effort to meet more of the legal needs of families, especially families with school-age children. And by doing so, they will able to address major issues of health and safety in our local students' areas' lives. The clinic supports the families attending Evanston-Skokie District 65 with free legal assistance and advice on civil matters, such as evictions or unemployment benefits, which are the subject of our other two trainings. Today, the focus is on family law, which is the second most common matter presented at the clinic. 1 in 5 families present with a family law related issue. Questions are common, such as how can a parent compel the other parent to pay for child support? Or how can one spouse get a divorce when they haven't spoken to the other spouse in years and they don't even know where they live? Or what are the rights when the child's mother dies and the sister of the mother wants guardianship of the child? Questions like these are common, and they're what we tackle on behalf of families and students at the clinic. And currently, our clinic, because of COVID, is remote, the same as the courts. And we do all of our case intakes by phone and by Zoom when it's comfortable for the clients. And if we represent in any matters, all those matters are currently done by Zoom with the court system. Our goal here at the clinic is to address family law issues because it impacts a child's well-being and success in our schools. And a child's health starts with having a safe and loving home, and even more so because of COVID-19 hardships on families. I'd like to now introduce Shaska Dice, my co-presenter today. Shaska is a distinguished career family law attorney, having received a very prestigious award this year from the American Institute of Family Law Attorneys as being in the top 10 best in Illinois. She is also a parent of a District 65 student, and she came to the clinic last year as a volunteer because she saw the flyer for the Moran Center's clinic in the digital backpack of her child that attends school. We're also fortunate enough to have her represent in a family law matter, and she's also been a great source of support to me as well as other attorneys with her expertise. So today I'd like to welcome Shaska and let her introduce herself to everybody as well.
Hi everyone, my name is Shaska Dice. I have been a family law attorney for approximately the last 11 years, practicing exclusively in family law. I am an Evanston resident. I have 2 children, one in elementary school at Lincolnwood Elementary in 2nd grade, and one in preschool. As Megan mentioned, I was that eager kindergarten mom who went through each of the flyers in the digital backpack and came across the Moran Center, and have been very happy and excited to volunteer my services over the course of the last couple of years. And I'm here hopefully as a resource for everyone who has questions with respect to family law issues.
Thank you for being here, Shaska. As we go through this presentation, if you have any questions, just put it in the question and chat, and throughout the presentation we'll answer them. So what is the purpose of the volunteers at the clinic, and especially in regards to family law matters? Well, the first, and what we hope you get away from this presentation today, is that this will give you the tools and tips so that you can advise clients of the next steps in family law matters so that you can help manage their expectations. And then you can also maybe take a case if you're willing to lend your time and talent and take a pro bono case and advocate for clients in a court proceeding. And then also knowing when it's necessary to refer clients to outside pro bono services, and other state agencies, which will go into more detail as we go out through the presentation. So before we move on, what I'd like to talk about is how important it is to know the basics of family law, not only because it's the second most common matter presented to our clinic, but also because it's a difficult time in our clients' lives. It's when they're most vulnerable. It's when we can help them access justice and help bring peace and support to their family. And we can also help them navigate the world's largest court system that they have to go through in order to get a divorce or parenting time or child support. Today, we're really going to focus on the basics of what's called allocation of parental rights and responsibilities. It was formerly known as custody. We'll also focus on child support and divorce. There's some other family law issues that come to our clinic that we won't really touch on much, but a little, which is adoptions and guardianship. And so when clients come to the clinic, sometimes what our main goal is to advise them how to proceed pro se. Because one of the things that we keep in mind at the clinic is that both parents could potentially use the Moran Center for legal advice. And so we really want to be sure when we do the case intake, figure out what is going on so that we can decide whether this is a case that involves us leveling the playing field because the other side has an attorney, or if there's domestic violence involved, or if we could help them get a divorce by default because the parent's completely absent and nowhere near being involved in the children's life. The other thing is at the very end of the presentation, we'll go over what cases we tend to accept, which are the uncontested, and where we will refer the contested cases and how we will help them file pro se. One thing to know is, or a question that comes in, is who qualifies for our services? And we base our representation on income qualifications. And so we base it on federal poverty guidelines. And just as an example, for a family of two, meaning mother and their child, they would qualify if she earned $57,000 or less. And that's just one example. If there's more children, that number goes down. So, and we have that on our case intake sheet, so that's all spelled out for you clearly so that you can help manage their expectations whether they will qualify for our services. And so why else would a volunteer need to know the basics of family law? Well, not only can you help manage their expectations, but you can also help advise them that they do have legal rights. And hopefully it will spark an interest in taking a pro bono case. And so I'd like to ask Shaska what her inspiration has been for advocating for families for the last 11 years, so that can help spark an interest for our volunteers to take on a family law matter pro bono.
Well, thanks, Lynn. I started off in family law really with the goal to help people through one of the hardest times of their life, if not the hardest. It's the breakup of a relationship, a breakup of a family, and guiding them, guiding an individual or family from the dark to the light side to hopefully get them through this difficult time, be the voice of reason, logic when emotions are running high. And really, we as family law attorneys often joke that we play counselor in both senses of the word. We're an attorney and advocate, but we're also there to be a sounding board and emotional support for our clients. And that has really been rewarding as part and parcel of the job over the years. In family law, there's also another saying, a joke between family law and criminal law attorneys. Criminal law attorneys meet bad people at their best and we meet good people at the worst. It's just trying to get people to see that everything is going to be okay in the end. And that was really been my hope and goal and inspiration throughout representing clients.
Thank you for sharing that. And you talked about how this is when you can really help somebody move from being in the dark to the light and helping them with one of the hardest time of their lives. And it is at the Moran Center, our approach is holistic. We have social workers that can help provide some of that therapeutic service as well. We also have other agencies that we partner with. And so it is really important that when we do case intakes, when we meet with clients, that we wrap around our services and recognize when there might be mental health needs as well, as we kind of shepherd them through this darkness and into the light. So moving to the next slide, we're going to first start with divorce issues and the basic grounds for divorce. There's, I think, a lot of misperceptions about how or why you can get a divorce in Illinois, but it's really been streamlined, and that the standard is irreconcilable differences. And what that means is no longer living as spouses for at least 6 months. And they call that 6 months a separation period. And it's not really a requirement, it's an option. The living separate and apart creates this irrebuttable presumption that the irreconcilable differences have caused the breakdown of the marriage. And living separate and apart doesn't mean living at a different address. It only means that they're no longer living as spouses should live. The other thing is that basic grounds for the divorce is jurisdiction. They have to be a resident of the state and the particular county for at least 90 days before filing, or the 90 days before prove-up. Shaska's helped me understand this better by, she can correct me if I'm wrong, but we do have a requirement to take a case that they have to have been living here for at least 6 months, but really, so long as they've been here 3 months, we could file, because by the time we get to the prove-up, we should be able to show that they've been living here for at least the 6 months and that they've met the 6-month requirement of irreconcilable differences. And then there's other fault grounds that were what we used to know, but those have basically been abolished. So there's no reality TV show here where we have to have somebody follow the other spouse to see if they're cheating on them. It really just boils down to if there's irreconcilable differences. And Shaska, if you could talk to us a little bit more about why is it important then to know about the reason for the divorce? Like if volunteers were doing a case intake, why should they even ask, why do you want a divorce?
So divorce, the statute that governs divorces is the Illinois Marriage and Dissolution of Marriage Act. It is a very nebulous statute. It provides guidelines, but not really a lot of definitives. And divorce cases in general are very, very fact specific when it comes to an allocation of parental responsibilities and parenting time. The facts of the case will determine how the best interest standards set forth in the statute are applied. They'll also apply to whether or not a client or a spouse is a candidate for maintenance, how to allocate the division of the marital property. So facts surrounding the marriage, the breakdown of the marriage are important to get as background so that you can craft your case moving forward, and also manage clients' expectations moving forward, and what to expect in court. The more facts that you have regarding the case and the people involved, the better you can apply them to the various different factors in the statute.
Thank you for helping us why to actually ask that question, because it can be pretty personal. But like you said, it can help manage expectations about how contentious it's going to be on the other side as well. And that is kind of a factor of whether or not we do want to represent. So now let's talk about maintenance. And from the clinic's perspective, the cases we've worked on have almost never involved maintenance because there's hardly any asset or income to talk about maintenance. But it is important, I think, to know because this could come up. And I'm going to turn it over to Shaska because she has loads more experience than I do about how maintenance is calculated. It's actually, I've taken a seminar on it and it took a whole day, but we're going to try and boil this down to a few minutes so that you can just have the basics of what is maintenance and what would a spouse be entitled to.
So the first factor that the court will look at, and you as an attorney representing a client or advising a client would have to look at, is whether or not the spouse would be entitled to receive maintenance. There are factors that the court will look at in making that determination. They are set forth in Section 504A of the Act. We've listed some here in the PowerPoint, but the party's ability to work, their earning capacity, if they have foregone career opportunities to stay home and care for children, their realistic earning capacity in the future, their ability to earn, to acquire assets in the future, that age, health. Those are all things that play into the determination as to whether or not they are a maintenance candidate. You will, there isn't any real hard and fast rule there. If you're checking the boxes in terms of the spouse has not earned an income versus another spouse who has during the course of the marriage, someone who has stayed home versus gone to, and worked outside of the home, someone who is in poor health versus good health. Those are things that are important to look at. Once that determination is made, or you can reasonably argue that your client should be a maintenance candidate, then a statutory formula applies. The statutory formula has changed over the course of the last few years, but currently it is 33.33% of the payor's income, net income, minus 25% of the recipient's net annual income to derive the maintenance amount. And then there's another formula with respect to duration, which is based on the length of the marriage. The length of the marriage is defined from the date of the marriage until the date of filing of a petition for dissolution of marriage. So it's always key to, if you are representing a client who believes that their spouse could be a maintenance candidate, it's good to know that the date of filing cuts off that duration, that defines that duration of maintenance that could be paid. And the duration is it's set forth in the statute, but it essentially is anything, if you've been married over 20 years, you would be a candidate for indefinite maintenance, which used to be called permanent maintenance. If you're under that, there is a multiplier that is applied depending on how long the marriage is. And there are resources online that can help you calculate out the maintenance. In terms of net income, there are two different standards that are used. There is a standardized net income chart, or that you can actually use an individualized tax, use the individualized taxes of the parties. It's federal, state, FICA taxes that are taken off of the gross to determine what someone's net income is.
It sounds like you need to be a CPA to figure out maintenance. Is there something you use that helps you out with determining it?
Really, especially in cases that potentially the Moran Center would be involved in, you really need to take a look at a pay stub to determine what the income of the parties, and then make a determination. And it's a straight calculation thereafter, a percentage calculation. The first and the key part is determining whether or not the client or the spouse is a maintenance candidate. Thereafter, it should be fairly straightforward to figure out how much and then for how long the maintenance should be paid for.
Okay. And so do you use software to help you with figuring out maintenance?
I do. There is software called Family Law Software. It is a great resource for maintenance and also child support, which we'll get to later, but has changed dramatically over the course of the last few years. And that takes into consideration tax filings as head of household versus single, and comes up with and gives you a pretty clear picture of what someone's net income is for maintenance and child support purposes.
Okay, so I kind of touched the button faster than I meant to, but the next thing we're going to look at is the division of debts and assets. And if you could just touch on like what are exception examples of debt or assets that are stemming from non-marital or premarital.
Sure. So presumptively, just to begin with, anything acquired during the marriage, whether it be a asset or debt, is presumptively marital. So if there are certain exceptions. If you have a premarital retirement account and you are then contributing funds to a retirement into that same retirement account during the marriage, you can that account can be treated as both premarital and marital. The contributions made during the marriage will be marital, and anything prior to will be considered premarital. There is also student debt is typically assigned to the spouse that incurred the debt. If you are a party to a lawsuit, a personal injury lawsuit, workers' comp, those proceeds are again presumptively marital. However, it's fact specific and typically are allocated more in the favor of the party involved in that litigation.
Charles, do we have a question?
We do have a question from Kristen Westman, who asks, what about inheritances?
Sure. So inheritances are presumptively, pursuant to statute, non-marital. As long, and I would advise any client to, if they are receiving an inheritance, to keep it segregated from keep it in your own name, keep it in a separate account. Do not transfer those inherited funds into a joint account or an account in both parties' names. Then that will essentially lose its identity. So you want to keep that inheritance separate, but inheritances are presumptively non-marital, regardless of when they are. If you get that inheritance during the marriage, doesn't matter. It's still premarital, non-marital.
Okay, thank you for that question. Keep them coming. So this is a petition for dissolution of marriage where there's no children. I show this one because it's a little bit more simple than with children. And these forms are readily available not only on the court's website, but also through Illinois Legal Aid Online. And I share that because, again, there's a lot of cases where we can't represent, but we can at least advise and assist them, help them find this paperwork or print it out for them, go through it with any questions they have on how to fill it out. And basically for our volunteers who work at the clinic, it is quite common where we help give them a petition for dissolution of marriage. And then we also just advise them on how they need to have the summons to file and also a 298 fee waiver. And so long as they appear at Skokie Courthouse, and it is open right now, there's an e-filing help desk, and that's how they start their case. And so it can all begin with the clinic helping them with the paperwork, and then they would need to go on their own. Sometimes It helps to know what the steps are in the process if the divorce paperwork is filed, so that you can help answer a volunteer or answer a client's questions about what to expect. And the first thing to do is to talk to them about what the summons process is and how they need to have a summons filed so that the sheriff can try and serve the other spouse. And a lot of times it's really hard to find the spouse. And so they could either try and hire a private process server. They could maybe even do publication or posting. There's lots of ways to get a divorce by default by getting service through a more creative method, so long as it is approved by the court. And then if they're able to get service on the other spouse and they do appear in court, then the next thing to let them know will happen is the judge will say, okay, well, let's see if we can do this, you know, if there's children, because most likely they would have children if they came to one of our sessions, one of our clinics, is they would be sent to mediation, and the mediator would try and help them come up to an arrangement for child support as well as visitation. And after those 2 mediation sessions, if they're not able to work it out, then you know, it could end up going to hearing. Experts or a GAL could be appointed. And so, you know, at this point, it's one of the things to tell them is there's a lot of people who go to court and get a divorce pro se, and they can do it. The judges are, especially Judge Reynolds at Skokie, is very good about explaining what needs to happen next. And there's help desks in the clerk's office that can help them file as well. One thing to note now during this pandemic is that things have substantially slowed down. Filings are delayed about 4 to 5 months. So if we filed today, it would be sometime next year where they'd have the first court date. Everything is done remotely. It's done by Zoom. And then lastly, you know, if they're able to get service, but the spouse doesn't show up, then you can proceed to prove up. And at that prove up, if they're proceeding pro se, again, the judge will ask all the questions that need to be answered to do the prove up. And if it's a volunteer who's taken the case pro bono, either myself or an expert like Shaska, when she has time, can help our volunteers put together their case so that they can prove it up in court. And again, we tend to take the cases that aren't going to be contested because those can take a long time. They can take, you know, a few years. So that's why, you know, we're really looking to only represent in cases where it's absolutely necessary, or we know that we can do it by a default divorce. And so we do figure out what cases we take on a case-by-case basis. I just want to share an example. I know these 2-star volunteers are here at this training right now, and they took a matter this past year where they did an amazing job for a client by really moving her from the dark to the light. She came to the clinic as somebody who ran away from a very bad domestic violence situation, went cross country, had been residing here for 5 years with her 2 children in our schools. And when she came to our clinic, she said, all I want to do is be liberated. I want to be divorced from him. And we don't know if he was deported or if he went back to the country he came from, but we took the case because we knew how much it meant to her. And so these volunteers held her hand, they walked by her side, and they were able to file for the divorce, get service by publication, and then do a default divorce prove up and help this mother of 2 children really move from the dark to the light. So now moving on to it's hard to get this vernacular down, but this is the lingo. It's parental rights and responsibilities. It was formerly known as custody and visitation. Clients that come to our clinic, they will use custody. They will use the word visitation. But if you stick with parental rights and responsibilities, we'll slowly get everybody used to saying this as well. And types of parental responsibility cases, they're either part of a divorce proceeding, or it's an individual case where the parents aren't married. But both are very similar in how they work. And so that's why we're moving from divorce into now parental rights and responsibilities. And again, this is whether they're married or not. They would be heard in the same court and follow the same process. I also want to just take a quick note here about other cases which kind of involve parental rights and responsibilities are guardianship cases. And we've had a few cases come to the clinic where it's a father who didn't have primary parental rights and responsibilities. In fact, there wasn't even any court proceeding about it. In fact, parents can just choose to parent on their own without having something formal in court. And these two fathers who had come to our clinic and we've represented and helped them with, in both cases, the mother died. And there was a relative who wanted guardianship of the child. And parents have primary rights to be with their children. And so we took both of those cases, and I just put that in there as something that we do handle, but it's not something we're going to get into deeply here, except for when we get to what's in the interest of the best interest of the child, which is a standard that they do use in guardianship proceedings. So how do we start one of these parental rights and allocation cases? Well, it starts with establishing paternity. And that means we might have a client come to the clinic who is the father, but maybe he's not established as the father legally. And so these are questions that would need to be asked in an intake to figure out if paternity has been established. And the same thing, if a mother presents to the clinic and says, I want father to pay child support, she would also have to establish paternity. And the gist of it is, if the mother's married when the child is born, then the spouse is the presumed parent. Now that can be overcome by the father filing in court and getting an order of parentage. And that is done by the court ordering a DNA test of the parties to establish parentage of the biological father. Another way that parentage can be established is if the parents are unmarried, they can both sign a voluntary acknowledgement of paternity, known as VAP, and both parents are listed on the birth certificate. I've had cases where somebody presents and says, well, yes, I'm on the birth certificate. And the question then is, well, did you sign anything? Were you present for the birth? And if they say no, then just being on the birth certificate isn't enough. And so there is a process by going to the HFS, that's the Illinois Department of Healthcare and Family Services website, where you can go through the process of getting a VAP on file. And there's a difference whether you do it within 1 year of the birth or after. And then the other two things to know, that you can also get parentage established by administrative proceeding under the Illinois Public Aid Code, or by contract, like as in an adoption proceeding. Charles, do we have a question?
Yes, we do have a question from Stacy, who asks, can you just mail the petition to the spouse if the spouse would not contest divorce?
Yes, you can, as long as that spouse will then accept service and file an appearance on his behalf. It gets a little murky when someone says they'll accept service by email and then they don't do anything to follow up on that. They don't file an appearance or file a response to a pending petition. Then the court will ask, well, what did you do to obtain service? Have you obtained service? You'd have to have something in writing acknowledging that he or she has received the petition and accepted service by email.
And on the court website, there is a standard form. It's a waiver of, or an affidavit acknowledging service of summons. And they can file that affidavit showing that they were given it either by email or maybe it was just handed to them by the other spouse. And so long as they file that affidavit, then it shows that they acknowledge service. That's a good question. All right, so now we are going to kind of go back in time and talk about old law custody. And the reason why is because it's not that old. It's 2016 when the vernacular changed, and also just the philosophical difference of why they changed it from custody to parental rights and responsibilities. And so it's good to know what the old law is because, number one, you might have a client who comes and they were divorced in 2015. And so you will see what was the prior language. Or you might have clients who come and they are just using what they think is the information and how things are decided now based on just talking to people who went through a divorce a while ago and they're still applying the old standards. So we're just going to quickly go through the old law. So it's custody judgments entered before January 1st, 2016 in divorce or parentage cases include the old language, and it's still valid. And the reason we need to know the difference between like custody and parental rights is that custody was the vernacular used to include decision-making for healthcare decisions, education decisions, and religion, and also the primary residence or visitation. So the child would live with a custodial parent and visit the non-custodial parent. And even today, if you go to HFS website and you use some of their tools, like they have a very good estimator calculator for child support, even HFS uses the term CP and PP, meaning custodial parent and parent, CP and P. And so they still use the old language as well. Old law about joint custody. So this was the term of art to say that the parents are capable of joint decision making. Like either we don't want to be married, but we're a team when it comes to our kids, or we were never married in a parentage case and we consult each other about the kids' activities. And joint custody would also look at visitation and that they split their time with the parents, or that children live primarily with one and visit the other, or they can live in one location and the parents alternate staying at the house. And so that's how they would use joint custody. And then now the new law, so now we're past 2016, but custody is still a term of art used, but it's only used in non-parent proceedings, like when grandparents or aunts or uncles are looking to establish guardianship. And so it's not used for parents, it's used for grandparents or other siblings who are trying to establish guardianship of the children. And again, the new term is allocation of parental responsibilities instead of custody. And the new law, visitation, same thing. It's used for non-parents, like when grandparents want visitation. We've had a case like that that has come to the clinic, and without getting into the details, establishing visitation for grandparents, it can be done. It's, guardianship for a grandparent could be more difficult, but visitation, it can be done, but it is a burden on the grandparent to show that their visitation won't cause an undue harm to the child. And it's just not as easy to get as the other parent. So just something to keep in mind. And so now let's talk about the new law. This is what we really want to focus on. And this is the allocation of parental responsibilities and rights. And so parental responsibilities includes decision-making, like education, healthcare, religious upbringing, all their after-school activities. And each area is decided separately. Even on the parenting plan, each one is whose decision is it? And it can be decided by the father. You can list it as being decided by the mother or both. And parenting time, that's the time the child spends with a parent and then the other parent. And the primary residence address is only necessary to list for purposes of school residency. But otherwise, at least in the law of Illinois, both residents of a child are seen as their primary residence. It's only one primary residence has to be listed for purposes of establishing school residency. And so the big thing to know is that parental responsibilities unbundled custodial rights. And so instead of giving it all to just one parent and not the other, it helped to sort of spread this out because so many parents are involved in raising their children together. And so, Shaska, what is your experience with this change in terminology, and what were some of the significant changes with the 2016 law?
So the 600 series, or the statute with respect to what used to be custody and visitation, was completely reworked in 2016. This, and with new numbers, new nomenclature, new terminology. However, the essence of the statute stayed the same. It did, as you said, unpacked the decision-making and the parenting time that a lot of parents used to combine. And it was done as a philosophical shift. The word custody was felt to be pejorative to the non-custodial parents regardless of where the children spend the majority of the time or who have decisions making authority over them. The fact is it still remain the same with respect to allocating decision-making and parenting time. It is those best interest standard factors that the court will still look at. There is a movement now towards a presumption that both parents are fit and able to parent their children and should be afforded equal parenting time. That has not been codified into the statute yet. It has been for the legislature numerous times over the course of the last couple of years. And I think the movement is that there will be a presumption that 50-50 parenting time or equal parenting time will be the standard unless there is something to sway the court's opinion as to why there should be a different schedule in place. Similarly, with respect to decision making, it is presumed that both parents would be able to make joint decisions in the best interests of their children. The court would have to be swayed from that with respect to these 4 tenets of decision making. So really, if you have a statute book or an old book from 2015, throw it out because all the numbers are different, all the terminology is different. Look at the statute now. It really doesn't change a lot of what we were doing previously, but it helps explain things a little clearer for your clients.
Charles, do we have a question?
We do. From Kristen Westman. She asks, who decides which parent makes the allocation decisions? What controls or what's the process?
I just lost my screen. Okay. So who decides? Ultimately, if the parents are unable to come to an agreement regarding that, the judge will decide. There are lots of steps prior to the judge having that ultimate decision, though. First, any case involving children in Cook County where the parents have not been able to reach a resolution between themselves is referred to mediation. The Skokie Courthouse has a great mediation service. So does downtown and other various suburban districts. With respect to Skokie, right now, mediation is occurring remotely via telephone. You need to engage in 2 mediation sessions in which the mediator will help come up with a proposed parenting plan. That is, if the parties do not reach a resolution mediation, then the next step is to bring the matter before the judge. The judge will likely appoint a guardian ad litem or a child's representative to make an investigation, interview both parents, the child, the children, any collaterals, to make a recommendation regarding who should have the decision-making authority as well as the parenting schedule. Again, it's a recommendation. It is made to the court and the parties. They may not agree with that recommendation, and then there's subsequent steps of getting a custody, what used to be called a custody evaluator, which is now called a 604.10 evaluator, appointed to make that, again, recommendations to the court. Ultimately, if all of these recommendations are not agreed upon by the parties, or the parties are not willing to codify that into an allocation judgment, the judge will ultimately decide, and that will be done via a trial, a hearing, a final hearing on the petition for allocation of parental responsibilities or petition for dissolution of marriage.
Do we have another question?
We have another question from Judy Royal, who asks, if the mother has an order of protection against the father with both children included in the OOP, will the father be able to get get allocation of parental responsibilities and rights for the children?
He may, yes, if he comes in on his own petition, seeks to either be allocated decision-making or parenting time, it is within the purview of the divorce court to grant that. Again, it would be under, most likely in that situation, a guardian ad litem would be appointed to make a recommendation regarding the appropriateness of that request.
So the question of who decides, it's a good segue into this next slide. This here is a petition for allocation of parental responsibilities. Again, you can find this on the court website. And, you know, again, in some cases, we'll have to help them file pro se. In some cases, maybe we can represent them. And it's really determined on a case-by-case basis. But a typical case that will come in is a parent who's not married and says to us, I want to see my child. The mother's not letting me see the child when I want to, and I want to see my child. And so some things to remember about that is, you know, taking them through the process of, well, yes, so long as you establish paternity, let's say that they acknowledge that they are on the birth certificate, they did sign a VAT, they can file that as proof, then they could file this petition. And the thing to let them know is it also triggers them paying child support. And so by all means, they should be able to exercise their right to see their child, and probably for even more than they are seeing the child. And if they're going to do this through a court proceeding, it will also trigger child support obligations. And then there's the opposite. There is the parent who comes and says, the other parent is not involved. I want them to support this child. I want them to take this child on the weekends. And again, it is something where we, if it's the appropriate case, either can represent them or help them file pro se, but also helping to manage their expectations that while child support is something that a court could readily decide, there is the state's attorney's office that can enforce it through garnishment of wages and also rules to show cause. It is really difficult to make another parent visit their child. There's just no judge that's really going to hold somebody in contempt for failing to visit their child, which is very unfortunate, but it's a reality that we have to talk about with helping to manage their expectations. So again, if we were going to advise them how to do this pro se, meaning on their own, they would use this petition, they would need a summons, and they would need their fee waiver. And they could go to the Skokie courthouse and file this and start their petition for allocation. So Shaska, if a volunteer was going to take on one of these parentage cases pro bono, should they use this standard petition or should they draft their own?
I would advise to draft your own petition if you're taking on a case pro bono. This petition, the statewide form petition, is that it's a form. It has very basic information that a petition for allocation of parental responsibilities would need. However, you want to use your petition as a means of persuasion. You want to add facts pertaining to the case into the petition. If your client wants sole decision making with respect to education, healthcare, and religion and extracurricular activities, why are they better equipped than the other parent? If the party wants to restrict parenting time or have a certain parenting schedule, again, why? Is it because they have been the primary caretaker throughout the course of the child's life? Is the other spouse not available? Those kind of facts will help the judge ultimately decide, if it gets to a judge, deciding how it should be decided. So always add it in more detail if possible.
Thanks for that tip on if a pro bono case is taken by a volunteer. Instead, use that as a skeleton, but put in the facts to really help advocate for the client. So if that's filed, you can help them know that they will be, the judge will see if they can first come to an agreement on their parenting plan. And if they can't, the judge will say, well, you should go to 2 mediation sessions. And if they can't come to an agreement on a parenting plan through those 2 mediation sessions, then the court may appoint a GAL. And some, depending on their financial situation, they may have to pay for the GAL, or the court may be able to find a pro bono GAL. And the GAL's really sole job is to represent the children and to help the court determine the best interest for the children. And the GAL becomes the eyes and ears of the court. They end up doing an interview of the parents, the children involved if they're old enough. And I'm just showing a few of the relevant factors in the statute, the 602.7. This is the best interest of the child statute, and there's actually 17 listed factors, and I've only listed a few here. But things that a GAL, or even if it goes to a trial, a judge would look at is what are the wishes of the parents and the children, or what's the relationship between the child and the parent? What's the relationship between the child and other siblings? Prior agreements, and what's the child's mental and physical health or needs? What's the distance between the parties? And so those are just a few of the factors that a GAL will go through, and usually a GAL's recommendation is what a court will follow. And if the parties still contested, it could go to a trial. I will talk a little bit more towards the end of this presentation about how at the Moran Center, we do have a pilot GAL program where we're looking to have volunteers certified through a process and to be part of being a pro bono resource for the Skokie judge. But before I get to that, I'd like to ask Shaska, how does a GAL fit into what happens if it goes to trial? If the judge, if they make a recommendation, the parties don't agree with it, how often do cases really go to trial, and what can we expect?
Custody trials are I just use the word again, but child-related trials are fairly rare because there have been a lot of safeguards put in place to try and prevent people from going to trial over child-related matters. The mediation, the mandatory mediation, appointments of GALs, having experts appointed to make recommendations. So they are rare. If they do go to trial, they are quite lengthy and really quite emotionally and can be financially draining if there are resources there. How does the GAL fit into this? They really are, as you said, the eyes and ears of the court when it comes to the children. Very, very, very rarely do children brought into court for examination by the judge or in-camera interview. That GAL is really the one that is reporting back to the court with respect to their best interests. So if it goes to a trial, the GAL is a witness, can be called as a witness by both parents, can be examined under cross-examination by both parents attorneys, and can testify as to the best interests of the children. So they could play a very critical role in a child-related trial.
Thank you for sharing your experience on that. This next slide, I'm going to move a little bit faster because I see we're kind of close to the end of our hour. We've had clients come to the clinic and ask, well, we already have an allocation judgment. How can I restrict the other parent's time because there's been a change in circumstances? Well, it has to be something that's a substantial and serious endangerment. For example, there's been abuse or neglect, calls to DCFS on the other parent that they're looking to restrict the time, or maybe drugs or alcohol or truancy. So it has to be very fact specific. And usually a GAL is appointed when somebody comes in on a motion to restrict the parenting time. And then going to child support. So now we've gone through allocation of parenting time and responsibilities. And now how about child support? Because this is a question that comes to the clinic a lot. And there's an old law. So if somebody comes in and says, I get 20% of his paycheck, this is where they're getting it from. But the new law is that there's this income share model. And it really is quite fact specific. And the best thing to do, Shaska was going to go through this, but you can read this on your own. It's really a fact-specific model. You have to have the parent's income to figure it out. And there really is a calculator out there. There's this very nice tool. It's free. It's on the HFS website. Again, that's the Illinois Department of Health and Family Services. And if you go to this and go to the child support tab and then to the estimator, it's basically a calculator, and you put in each side's income. Is anybody paying for medical expenses? How many nights does, and they use the word custodial parent, but how many nights is the parent who primarily the child is residing with have? And when you add all that in, it'll estimate what they can expect in child support. So for our STAR volunteers and for our new volunteers, we provide a family law case intake questionnaire at the clinic. And it's in our volunteer handbook for when you're doing these intake calls remotely, so that you can go through some of the questions that are important just to understand the case, so we can assess it to see, do we need to advise them to proceed pro se? Could we possibly find a volunteer to represent them? Or do we need to refer them to an agency such as HFS where they could enforce the child support obligation? And so these questions are available. And I promised in the beginning I would talk a little bit more about our case intake considerations. And this slide really goes through it in detail. Questions to ask at the intake to see, you know, have they been separated for at least 6 months? Because we're talking about will they trigger that irrebuttable presumption that there's irreconcilable differences? Have the children resided in Illinois for at least 6 months? And again, you know, if it's around 90 days, we may be able to work with it. And really, any other questions to see if we can expect there to be a contest on the allocation from the other side. Because again, these cases take a while. And I certainly understand the hesitancy of volunteers to take a case that could take well over a year. And then just looking to see if the property is less than 50,000, to see if there's income qualifiers and not going to really be an issue about maintenance. These are services to refer them to. If there's domestic violence, you could also refer them to the YWCA. And lastly, if you find right there and then they're just simply not going to qualify for our services, then we provide them with what's called a no representation letter, and we can also refer them to other agencies such as CARPLs or the CBA Lawyer Referral Service to see if they can get some type of sliding scale representation there. And then lastly, I promised I would tell you more about how to become a guardian ad litem child representative so that you could potentially take a GAL pro bono case from the Skokie Courthouse. And the way to do it is Chicago Volunteer Legal Services offers a guardianship certificate program. It's 2.5 hours. It can be done online, and here's the website. So long as you do that 2.5 hours and you take at least 3 pro bono cases, you can then qualify to be on the GAL list if you apply to Judge Dickler. There's about 200 GALs who are on that list right now for all of Cook County. And it is a very nice way to give back to the community and to be in a position on these family law matters where we're advocating for the youth, for the children, and not taking one side or the other. And so this is really the goal of the Moran Center. We would rather be the GAL in a case and look out for the best interest of the children than representing one parent or the other. But again, we look at these on a case-by-case basis. And other resources for child support are listed here. Illinois Legal Aid Online just has so many good resources. If you have questions that come up at a clinic, you can literally use that to help you navigate through some might be more specific issues. And just the Illinois Department of Health and Family Services has their child support division for any child support issues that come in as well. And so thank you everyone for coming to this training, volunteering your time and talent for those who are current volunteers. And I really encourage everybody on here who's new to the Moran Center to consider lending your time and talent by emailing me afterwards, and I can talk to you more about our onboarding process. Before we say goodbye, I just want to check to see if we have any other questions. If you do, you can submit them in the chat. If you have any that come up afterwards, you can always come back to me by email or by phone. Charles, do we have any other questions?
None at the moment. You know, if we want to give a few minutes for people to type.
Yes. And so while we wait, you know, in the beginning, Shaska shared, you know, kind of like a joke, family law joke among them. And as I was kind of tooling around on the web, I found a quote that made me stop and pause, and it's about child support. And this quote said, "They should stop referring to it as child support when it really is a small donation towards a get out of parenting free card." So just know that child support is a really basic right and need that some of our parents should absolutely access so that they can support their children and that they can have the safety and health and care that they need at home so that they can thrive in school. And as I was tooling around, I also saw another quote from Jennifer Weiner, where she said, "A divorce isn't such a tragedy. A tragedy is staying in an unhappy marriage, teaching your children the wrong things about love." And so as Shaska said in the beginning, it can be really rewarding to help somebody in one of these matters and helping them in one of the darkest times of their life. So if there's no questions, then we'll say goodbye. Shaska, thank you for lending your expertise, your experience.
Thank you for having me.
Wonderful. All right, this will be posted on our webpage if you want to see this recording again. Thank you.